Now class, let's move toward this act. If we say that Indian Contract Act 1872. So this is a very old act and still we are following this law. Why? Because whatever the rules and regulations that is made for the contract, that rules and regulations are right. That's why we are following this law. Is that okay? Now, what is contract? See class, by seeing the act name now, you can easily understand what this act signify. So this act signify the rules and regulations of the contract. So if I talk about the contract now, so simply suppose if you all go to the restaurant for eating, you all people just take movie ticket for the movie theater, you all people do shopping, right? You all people have taken this paid bat. So what is this? So these are the examples of contract. So what exactly contract? See, if we are going for the shopping, so the shopkeeper will not give, suppose if I just go in a clothes shop, so the shopkeeper will not give cloth in a free of cost. The shopkeeper will take some money. That money in legal term it's called consideration, and we also take cloth from the shopkeeper by giving the money. So cloth is the consideration for me and price is the consideration for shopkeeper. So in the contract, in the restaurant example, in the movie example, shopping and the paid class that you have taken, something for something is there. It means give and take. Give and take is there in all the example. So this is called contract. So this is the particular syllabus of Indian contract. We have to study intro, meaning of contract, key components, essential valid contract, and the contract act and the bank. It means what is the relation of contract act and banking. That is so simple. Okay, now class, let's move toward the topic. See, this act come into force in the first day of September 1872. It applies to the whole of India. It means in all over the state, the Indian contract apply. This act is basically divided into two parts. So first is special principle of contract and the second is, first is general principle of contract, second is special principle of contract. In general principle of contract now, we have to study the rules and regulations of simple, a simple rules and regulation how the contract form. So the first part contains section 1 to 75, but you do not have to study all the section because your section based question always come 2 to 3 question. So what are those sections which is important? So I will give you a hint. I will just tell you that this section is important, so you have to learn that section. So in the Indian contract, which is divided into two parts, the first part is from 1 to 75 section and the second part is from 124 to 238 section. And the total section in Indian contract is 266. Now my question is, where is 76 to 123 question, 120 section, and where is 239 to 266 portion? Yes class, please tell me where are these portions? Yes ma'am and sir. Indian contract contain total section that is 266. Okay. General principle 1 to 75. 76 to 123 is missing. And 239 to 266 section is missing. Now tell me where are these section in Indian Contract Act? Any idea? The answer is given in this slide. The answer is given in this slide. Yes, class. Yes, tell me. That is very simple. The answer is already given in this slide. Tell me where are 76 to 123 section and where is 239 to 266 section? Yes, Sarita ma'am. Please tell me. Excellent. Ready, sir? Excellent. So guys, 76 to 123 is now removed. This section has been removed and a new act is made, that is Sales of Good Act. And again guys, 239 to 266 section is deleted from Indian Contract Act and the new act is made, that is Partnership Act 1932. So we have just make a separate act. Otherwise, these two acts are the part of the Indian Contract Act. But in 1930, we just make Sales of Good Act, and in 1932, we just make a Partnership Act. And guys, these two acts are the part of the syllabus. These two acts are the part of your syllabus. So that's why these two acts are important. Okay, so this is just a crux of your Indian Contract Act. Okay, now let's understand the basic thing that we have to study in the General Principle of Contract. The General Principle of Contract class, this portion is not anything but this formula. So I will give you one formula and you can easily understand what contract is and what we have to study in the General Principle of Contract. Okay, suppose Guru sir, this is Guru sir, and that is a restaurant. Guru sir, you just went to the restaurant for eating food, right? You just offer that I want butter chicken and tandoori roti. Restaurant say, sir, the price of butter chicken and tandoori roti is, suppose, 1,000 rupees. Okay, the price of the food is 1,000 rupees. So if Guru sir is offering, I want this much, and restaurant is accepting the offer. So when offer is accepted, that is called promise. So guys, promise is nothing but offer plus acceptance is equal to promise. And the promise in legal term, it is called agreement. Promise in legal term, in law language, in the language of the law, the promise is called agreement. So class, now a short formula, offer plus acceptance is equal to agreement. And class, the agreement are various type. Agreement is suppose social or you can say domestic agreement. Next, religious agreement, and then legal agreement. Okay, these are the three agreement. Domestic agreement means offer plus acceptance is equal to agreement. Social agreement example means suppose if a father is say to the wife, if the father is say to just children that I will give you bike if you crack this NEET exam. Suppose his son cracked NEET exam, but father not give bike. So tell me class, in this case, can son file the case on his father? The father promised that I will give you bike if you crack the NEET exam. The son cracked the NEET exam, but the father doesn't give bike. So can son file the case? The answer is no. So class, this agreement is social and domestic agreement. So social and domestic agreement, we cannot file the case. Religious agreement, if someone promised that I will give you 10 lakh rupees in making of this temple, but next day I just revoked my offer. So in that case, the priest of the temple will not file the case. But in legal agreement, suppose if you people have offer that I want Sankalp English medium batch, okay, and the Adda say, okay sir, the price of the batch is 5,000 rupees. So you are offering, Adda is accepting. That is called legal agreement. In legal agreement, when the law will enforce. What is law enforceability? Law enforceability means in which you can enforce your right in front of the court. That is called law enforceability. So when you will enforce your right, when your right will be violated. Suppose if you have given the price of paid batch, but Adda is not showing you the batch. So in that case, you people have a right to file the case in front of the court. So in the legal agreement, there is a law enforceability. It means you can file the case in front of the court, and this is called contract. So in one word, in any agreement, when the law will be enforced, that is called contract. And consideration, suppose if you people have taken the batch, so the teaching is your consideration and rupees is Adda's consideration. So in the legal agreement, there must be law enforceability and consideration must acquire. This is called contract. So guys, this is the formula of contract. So with Sarita ma'am, in the general principle of contract, you have to study only what is offer, what is acceptance, what is agreement, etc. So this is the formula that you have to understand. Okay, offer plus acceptance is equal to agreement. In agreement, when the law will enforce, that is called contract. And consideration also must be there in the agreement. Okay guys, now this is the formula. This is the formula that we have just read. Now class, the definition terms. See, these definition terms are the language of your contract act. But in my language, I have already told you what is proposal, what is acceptance, what is promise, what is promisor, what is promising. Now see the language of contract act. What is promisor? The person making proposal is called promisor. Promisee, the person accepting the proposal is called promisee. Accepted, a person to whom proposal is made signify his assent. The proposal is called accepted. And what is proposal? When one person signify to another his willingness to do and not to do something and obtain the consent of that other person, that is called proposal. A very simple definition. So class, the definition types of question now always come 5 to 8 question. Definition term. Suppose this language will be there and the 4 words will be given you. Proposal, acceptance, promise, and you have to tick mark on the correct word of the definition. So that's why, suppose if I complete module D, on that day I will give you the definition terms of all act. I will give you the summary of all act. So summary of the act and the definition I will give you when the module will be finished. And this is very important to just learn the summary and the definition term, because from the definition terms 5 to 8 question definitely come. So guys, any doubt in this definition term of the contract? Any doubt in the definition term of the contract, please tell me. Any doubt, class? Yes, Soren ma'am. Any doubt in this definition term of the contract? Clear? That's great. Now class, first of all, please read this section 10. Please read. Hanji. So tell me class, section 10 that you have to understand. Section 10 is important. You have to learn section 10. So I'm just telling you the one word of section 10. Section 10 is basically about the valid contract. Section 10 talks about the valid contract. Is that okay? So what is section 10? See, section 10 say that if someone is pressurizing you to just purchase the batch, that is not a valid contract. So the contract must be of free consent. There must be competent to contract. There must be competent to contract. Competent means, Ramesh sir, you are capable to understand what is right and what is wrong. It means you are capable to do contract. And Adda is also. So in a valid contract, the party must be capable to contract. There must be lawful consideration. Ramesh sir, the teaching service is lawful consideration and you are giving the price, that is lawful consideration. Suppose if you are giving drugs, that is unlawful consideration. So there must be lawful consideration. There must be lawful object. There must be lawful object. Okay? Lawful object means your aim is to crack CAIIB. So to crack CAIIB, that is a lawful object. Okay? And your terms and conditions should not be void. So what is void? Void means basically that is not, you can say it's a null and not enforceable in a court of law. Null and not enforceable in court of law. So class, this is the essential point of valid contract. So we know what is contract. Contract is equal to agreement plus enforceability by law that we have just studied. So that's why these are the essential points of valid contract. Now class, you have to tell me this meaning of the line. All contracts are agreement, but all agreement are not contract. Please explain me this line. Yes, Arvind sir, Guru sir, please explain me this line. Yes, class. Please explain me this line. All contracts are agreement, but all agreement are not contract. Yes. Please explain me this line. All contracts are agreement, but all agreement are not contract. This is the crux of the previous two slides. If you explain this slide, it means you understand whatever I have taught you. All contracts are agreement, but all agreement are not necessary contract. So class, if I am saying all contracts are agreement, so class, we know the formula of contract now. Offer plus acceptance is equal to agreement plus law enforcement is equal to contract. So if I'm saying contract, so it is come from this line now. So agreement is already there. So that's why all contracts are agreement. But all agreement, that is social agreement, religious agreement, legal agreement. So social and religious agreement are not contract because we cannot file the case. Exactly, Arvind sir. We cannot file the case. So that's why all agreement cannot be necessarily convert into the contract. So this is the simple formula. Okay. Now, so guys, we have just done the crux of the general principle of contract. Now we are going to start the essential points of contract, and essential points come from section 10. Essential points come from section 10 class. So that's why section 10 is very much important. You know, section 10 is also known as the backbone of Indian Contract Act. Section 10 is known as the backbone of Indian Contract Act. That is important. Okay, the backbone of Indian Contract Act, section 10. Okay, now one by one, we will understand the essential points of contract. See class, there must be at least two parties in a contract. Yes, two parties means one will be promisor. Promisor is also called offerer. So offerer is a person who offer. And second, promisee and offeree. So promisee is the person to whom we are offering. To whom we are offering, that is called promisee. So you have to learn the party's name, that is promiser and offerer, promisee and offeree. That's it. Okay. Next, there must be offer, there must be acceptance. In any contract, yes. So now, what is the thing that is different in this line? Offer must be clear, defined, communicated to the offeree. Clear and defined means, suppose if Nikita ma'am is saying that I want to sell my car. Now tell me, this is clear offer. Yes, class, tell me, it is clear offer. Yes, tell me. If I'm saying that the offer, just I want to sell my car. Tell me, this is clear offer or not? I want to sell my car and Nikita ma'am have a 5 car. Nikita ma'am have a 5 car and I'm saying that I want to sell my car. The offer is clear or not? Please tell me. I didn't told that which model is there, what is the color of the car, what is the name of the car. Okay, I didn't tell these things. So it means my offer is not clear. So if I'm offering that I want to sell my car, I have to tell the model name of my car, the name of my car, and to whom I want to sell. So in offer, these 3 things are essential to understand. Exactly. Exactly, Arvind sir and Hemant sir. So offer must be clear, defined, and communicated to the offeree. And acceptance must be absolute and unconditional. What is unconditional? Acceptor. Suppose if Nikita ma'am want to sell my car to Ramesh sir, so Ramesh sir will not give any advice. Ramesh sir will not give any condition that Nikita ma'am, you have to give me your car on this day, no. There should be no condition from acceptor side, and acceptance must be absolute. Absolute means a very simple term. Absolute means that is, suppose if my car is there, the price of my car is 20 lakh, but if Nikita ma'am is selling this car only for 1 lakh to the X person. So tell me class, 20 lakh the price of my car and I'm just selling it only for 1 lakh. This is valid or not? Yes, tell me. This is valid or not? If I'm selling my car only for 1 lakh. Tell me. If I'm selling my car, the price of the car is 20 lakh rupees and I'm selling it only for 1 lakh. So guys, this is valid contract because it is without any pressure. So this is a valid, this one, okay? So now you have to read this example by yourself. This is the homework. This is the homework, okay? Now, one thing that you have to understand, invitation to offer is not offer. Suppose if a shopkeeper is selling his items and the sale is given, suppose sale 80% sale, 90% sale, 50% sale is there. So what is sale? Sale is called invitation to offer. Suppose if a shopkeeper is showing 80% sale, so shopkeeper is inviting us to come in my shop and take the things. Suppose if Nikita ma'am select one sari, the sale of the sari is 90%. If I just go to the shop, now invitation to offer is convert into the offer, and rest of all the contract definition will be go on. So it means class, I think you people know the definition of formula of contract. Offer plus acceptance is equal to agreement plus law enforceability is equal to contract. Okay. So guys, invitation to offer comes before offer. So this is your invitation to offer. So it is not compulsory that you have to convert invitation to offer into offer. It is your choice, because shopkeeper only show the sale that is 80%, 90%. Now it is you that you have to go to the shop and purchase the items. So invitation to offer, it means the shopkeeper is just inviting you to come in my shop and purchase the things. So that's why invitation to offer is not offer. That's it. Okay, so these are the 2 points. Now the next one. There must be proper offer and proper acceptance with the intention to create legal relationship. So guys, in the social agreement, in the religious agreement, there will be no legal relationship because we cannot file the case. But in legal agreement now, there must be legal relationship between the parties. Suppose if you people purchase the CAIIB batch, you people have given the price and Adda is giving you teaching services. So there is a legal relationship between you and Adda. Legal relationship means you can file the case if the classes will be not there. And Adda will also file the case if you will not pay the full price. Okay. Now, one famous case, Balfour versus Balfour. C class. In your exam, the case studies question also come. So this is called case studies question. So in the case studies question, the fact of the case will come and the 4 option will become. So you have to understand this particular case and then you have to do the answer. Okay. So in the Balfour versus Balfour, see what is happened in this case. The husband promised to wife that I will give you 20,000 rupees each month because you are not well. But after 3 months, if husband stopped giving price to the wife, now wife filed the case to the husband. So tell me class, this is a legal one or not? This example. This is legal one or not class? Please tell me. This is legal one or not? The answer is exactly. This is called a social agreement. Excellent class. Now suppose class, I'm just giving you another example. Suppose in the case of husband and wife got divorced. In divorce, the court ordered to the husband that you have to give to your wife maintenance of 20,000 rupees. Maintenance means the allowance that husband have to give. Suppose if husband gave only for 3 months and after 3 months husband stopped. So can wife file the case on husband in divorce case in the maintenance? Yes, Selvi ma'am. Excellent. Because in divorce case it is compulsory. In this case there is a legal relationship. Excellent class. So this is called what? Case studies question. So case studies question always come from the fact of a particular case. So no need to remember the case name. Just try to understand the fact of the case. That's it. Okay. Now, there must be mutual consent of the party. What is mutual consent? Mutual consent means if Nikita ma'am is giving red BMW car for sale to Ramesh sir, so Ramesh sir also have to think that Nikita ma'am will give red car. If Ramesh sir will think white car and I'm thinking red car, this is not mutual consent. So in any legal contract, in any valid contract, there must be mutual consent of the party. Okay? And in the legal term, the mutual consent is called consensus ad idem. What is this? Consensus ad idem. It means same thing in the same sense. Same thing in the same sense. This is called mutual consent. Same thing in the same sense. That's it. Okay, same thing in the same sense. Okay, guys, now a valid contract must be A valid contract must be free and genuine consent. I'm giving you one example. Suppose a person with a gunpoint say to me, give me your property. Okay, give me your property. B person sign the contract and give property to the A person. The contract is done, but this is not valid contract. Why? Because in this contract there is a no free consent. So coercion means to deter someone. Deter means darana. Undue influence means to influence someone. Fraud, to deceive someone. Misrepresentation, wrong presentation. So in all the four cases, that is coercion, undue influence, fraud and misrepresentation, the contract will be void from the behalf of B person. Because A have done coercion, A have done undue influence, A have done fraud, A have done misrepresentation. So in that case, B have an option to file the case, okay, and breach the contract. So a contract in which only one party have right to file the case, this is called voidable contract. This is called voidable contract. So what is voidable contract? In which only one party have option to breach the contract. So in this case, B person have a right to breach the contract. B person have a right. So A person is doing coercion. Second, A person is influencing B that if you will give B your property, you will be crack CAIIB exam. So under the influence of A, B gave all the property and the contract is done. But when B come in conscious mind, in that case, B will file the case. If A is deceiving B and if A is presenting wrong things in front of the B person. So in all the four cases, the contract will be voidable. So voidable means only one party have option to breach the contract. That's it. So tell me class, these 5 points clear or not? And in mistake also, the contract can be void. Tell me class. Yes class, please tell me. Clear, Arvind sir? That's great. So right now, you people know valid contract, voidable contract. Valid contract means section 10 and voidable contract means only one party have right to breach the contract. And when he will breach the contract? When the contract will be done by coercion, undue influence, fraud and misrepresentation. That's it. So these are the 5 points which is very much important. Now class, see. So this is the definition of voidable contract. You can see. So voidable means any such contract may be set aside either absolutely or if the party who was entitled to avoid it was receive any benefit upon such terms and condition as the court may see fit. That's it. Okay. You can see the example here. Okay. In this first point, forgery is there. In the second point, undue influence is there. Okay. In the both example, the contract will be voidable. Okay. Now, sixth point. Any contract, the performance of the act must not be impossible. Suppose in any contract, if I say to Puneet sir, if you will touch the star now, I will give you 1 crore rupees. So Puneet sir, tell me, is that possible? This contract is possible, sir. Yes, Puneet sir, this contract is possible. Hanji, Puneet sir, is that possible? If I say that please touch the star, I will give you 10 lakh rupees. Is that possible? The answer will be, tell me class, the answer will be, exactly, the answer will be not possible. So guys, contract must not be impossible. Agreement in any contract must be certain, that is clear. It can be oral also, it can be written also. It must not vague and indefinite. Not vague means the contract must exist in reality. You cannot make contract in just, hawabaji. You cannot make contract in a illusory manner. So the contract must be clear. It can be oral, it can be written, etc. That is 7th point. Okay, next. Parties must be competent to contract. What is competent? Competent means the person who is capable to do any contract. Major can do contract, sound mind can do contract, not disqualified by law. The person should not disqualified by law can do contract. Now, in this point, I'm just going to tell you the person who is not qualified to enter into the contract. The first is minor, below 18, lunatic, that is a mad person, and the person disqualified by law. So these are the 3% that cannot do contract. Now class, again, one of the most famous case, that is Mohari Bibi versus Dharmodaj Ghosh case. This is very, very much important case. Mohari Bibi versus Dharmodaj Ghosh case. So in this case, what happened? Okay, in this case class, a minor is there. Suppose X is the minor, that is 15 years of age. X want money from Y. Y is a major person. Okay. Y give 20 lakh rupees to minor, and Y didn't know that X is a minor. And in 20 lakh, X give land as a security to the Y person. X give land to the Y person as a security. Now in this case class, when Y get to know that X is a minor person, now he want to breach the contract. So the court held that first of all, the Mr. Y, the agreement that you have made, this is called void agreement, because you cannot make contract with minor. So if you are just doing contract with X, this is not called contract. This is called void agreement. So void agreement means that is beginning, it is void. And you cannot take your money. Y cannot take back 20 lakh rupees from X person. This was the decision which is given in this particular act. See, the court held that agreement made by minor was void ab initio, and there was no question of refunding the money. What is void ab initio? Initio means from starting. So void ab initio means void from the very beginning. Void from the very beginning. This is called this one. Void from the very beginning. See the last line. See the last line class. Void from the very beginning. Any doubt class? Please tell me. Any doubt class? So this case is important one because the question already come from this case. The question of case studies already come from this Mohari Bibi Dharmodaj Ghosh case. So that's why this case is important one. Yes class. Any doubt? Any doubt, class? So this is very important and the landmark case, Mohari Bibi versus Tharmodash Ghosh case. Okay, now see. If we talk about the sound mind person, so what is sound mind? Sound mind means the person who is capable of understanding and forming a rational judgment. That is called sound mind. That is called sound mind. Okay, now these 2 points are important. Suppose if a person usually unsound, usually means generally, suppose if a person is generally unsound, but occasionally means suppose out of 24 hour, 1 hour, that person is sound mind. So when that person is sound mind for 1 hour, so in that 1 hour, the person can make contract. In second point, if a person is usually sound mind, but occasionally unsound mind, so when he is unsound mind, he cannot make a contract. It means the contract will be always made by sound mind person. That's it. So this is your section 12. No need to learn section. Right now, you only have to learn section 10. Any doubt, class? You can see the example also. A patient in a lunatic asylum who is at interval of sound mind may contract during those interval. And C class, the expert, the doctor will decide whether that person is a sound mind or unsound mind. Suppose if you want to prove that opposite party is unsound mind, so you will not prove, the expert will prove that opposite party is unsound mind. That is important. That is important. Okay, so this is your section 12. Now, in any contract, there must be lawful consideration. It means something for something. Price of the promise. And class, we know that any agreement without consideration is void. Exactly, because in any contract, there must be consideration from both sides. So if any agreement in which consideration is not there, that is totally void. Okay, so void, you can say here, void means no legal effect and not enforceable by law. That is called void. Okay, now I'm going to tell you the exception of this line. Exception means an agreement without consideration can be valid also. What? An agreement without consideration. Okay. Arvind sir say that if a person during sound mind make a contract, then become unsound. Cease. Arvind sir, suppose if a person have done the contract when he is sound mind. Sir, on that day, the person is sound mind, the contract will be valid. After 10 days, he become unsound, that doesn't matter. Because contract will be effect from the date when you just make the contract. Arvind sir, is that clear? So the contract will be valid. The date of making contract is important. Okay, that's it. So class, what I'm saying right now, I have told you an agreement without consideration is void. But right now I will tell you the exception of this line. Exceptions means agreement without consideration can be valid also. So now in which case, ma'am? See, that is the first case. Suppose if a father is giving land, that is a personal property of father, to his son. So the father will not give this land verbally to his son. The father will give this land in a proper written contract. So in this example, the son is giving nothing, but father is giving land. This is a valid contract. So guys, if any agreement is made out of natural love and affection between parties standing in near relation to each other, okay, and in writing and register. So this part must be, these three essential points must be fulfilled if the father is giving property to his son. So this is called valid contract. Because C class, There's a no consideration from sun side, but still this is a valid contract because this is the exception of whatever we have read. Okay, this is the exception. Second, a promise to compensate a person who has already done something voluntarily for promisor is enforceable at law. It means, see the example. A find B's watch and give it to him. B promises to give A rupees 100. This is called contract. This is called contract. Because when A found the watch, he didn't think that B will give me something. But B promises to give something. This is called valid contract. So these 2 points are the exception of whatever we have read. So class, tomorrow we will finish the general principle of contract. So today is the first day, and I hope so you people understand the general principles of contract. Only 2 to 3 slides is left. So tomorrow I will teach you these 2 slides. Okay, that's it. So how's the class, sir and ma'am? Hemant sir, Arvind sir, ma'am, how's the class? So guys, law is nothing but a common sense and logic. And in each act, I will also give you my personal questions, Puneet sir. Suppose when I will finish Indian Contract Act, on that day, I will give you the question of Indian Contract. So 25 act is there. I will give you 25 set of questions. And in your app also, there is a chapter-wise quiz. So you have to also solve the quiz of that chapter. Hemant sir. Okay, I will give you personally questions in handout, and you can also solve the question in quiz that is in your app. Thank you so much. And whatever I'm just showing you in the presentation now, that is really very, I think, a perfect material. No need to go here and there. No need to go. That presentation is sufficient. My question, quiz competition, mock paper, that's it. And when I will finish the module, I will give you summary sheet, I will give you definition terms. So these are the complete material that I will provide in this particular batch. Okay, it's Ala Jangni Srilatha ma'am sir. Right now, we are focusing on July session. When the July exam will be finished now of CAIIB, then we will start a fresh YouTube session for November exam session. Okay, ma'am? So right now, there is a no YouTube session for the CAIIB because we are focusing on the CAIIB July 2024 candidates. Okay, thank you so much. And do not forget to give the feedback when I will just close the session.